In this recording, we're going to look at the area of law known as tort. Tort is the mechanism in civil law for making people responsible for wrongful actions. Here, we're going to look briefly at a series of small areas of law: tort, assault, battery, false imprisonment, and so on. We'll spend a little bit more time with the tort of defamation, but the large area of law that really makes up the bulk of this area in legal practice is known as the tort of negligence. We'll also spend some time looking at the way that damages are calculated in tort, both in negligence and in the specific torts. Before we look at tort specifically, I'm going to step back a little bit and just start with some really basic definitions. In civil law, that is the law of citizens usually bringing actions against other citizens, there's this concept of a cause of action. Now, cause of action is a thing or a series of things that have to be proven to the court by the person bringing the action, usually referred to as the plaintiff, in order to get some form of result or remedy. And some examples of this we've already looked at in earlier recordings, and they include things like breach of contract, and also the various vitiating factors: misrepresentation, mistake, undue influence, unconscionable dealings, and so on. There are some other areas of law that a person can bring an action to the courts under. For example, where a person has breached the conditions of a trust, for example, or if there's a particular statutory duty, for example, duties to not discriminate on the basis of sex or race, for example. Parties can go to the courts and seek some form of remedy under those areas. There's also an old area of law known as bailment that we'll look at in a later recording. And finally, this broad category that we're looking at is called tort. Now, tort itself just means a civil wrong in the general sense, but each of the causes of action we're going to look at has essentially its own blueprint, its own series of elements that need to be proved to the court in order to get some form of remedy, usually damages. Now, the important thing to note about elements, and these are the series of points of law that need to be proved to the court, and the important thing to note is that they are conjunctive. That means that the person bringing the action must prove all of the elements of a particular action in order to succeed in that. If you don't succeed in one of them, then your action will fail. Now, what we call the burden of proof, that is the standard by which the court needs to be persuaded. Now, the classical, conventional civil law standard is on balance of probabilities. That is, the court must think that it's more probable than not that the person bringing the action has succeeded for a particular element. And this is different from the areas of criminal law, where both criminal and regulatory offences need to be proved. Each element must be proved beyond reasonable doubt. We'll leave that aside for the remainder of this recording. However, in both the civil and criminal sphere, there's a few terms that do crop up that are sort of used synonymously throughout both areas. And first of these is what's called fault, the finding of fault. And this is very broadly used to describe the elements in either a civil cause of action, but also in criminal offences as well. It's a way of allocating responsibility to a person through their wrongful conduct. This and some examples of this are intention. Some torts and some crimes require the party bringing the action to prove intention on behalf of the wrongdoer. And negligence itself is also what we call a fault element. There are, however, some causes of action that don't require fault to be found. And we can think of this, I guess, intuitively. Areas of law where if a set of circumstances arises, it doesn't matter whether a particular person, the defendant in this instance, is at fault or not. A classic example there is breach of contract. We've already looked at that. If a party is in breach, in other words, a set of circumstances arises, meaning that that party is not doing substantially what they said they were going to do, the other side can seek some form of remedy. It doesn't matter at all whether the breaching party, whether they were at fault or not, whether they intended to breach, or even whether they were negligent in terms of breaching the contract. It doesn't matter. Liability in that case is strict. Another type of liability that can be attributed to a person is through what we call vicarious liability. What that means, simply put, is that if you, either as a natural person or a corporate entity, if you assign people to be your agents or as your employees, what happens when they are going out into the world is that they can both bind you in contract and they can also make you liable in tort. And so vicarious liability simply means that if your agents are acting within the scope of their agency or employees are acting within the scope of their employment, that you are going to be liable as the principal for their actions in tort law. Some other points to note about tort is that where we use the term intention, that as well as including and encapsulating situations where a person actually does intend to do something, it's a little bit broader than that. When we use the word intention, we include both actually intending, but also situations where a person is so completely indifferent or reckless about what they are doing. In those situations, they're going to be deemed to have intended to commit that particular tortious action, where intent is an element of that particular cause of action. Some torts we're about to talk about have directness as an element of that particular cause of action. What that means is that a person must either directly, in other words, themselves, do the particular physical thing, or they can set about a chain of acts or actions that still nonetheless are deemed to directly follow the particular initial act. So the example here in Scott and Shepherd, there the defendant had what we call a squib, which is a little ball filled with gunpowder and having a fuse, and they threw it in the marketplace, and somebody caught it or grabbed it and immediately threw it to the next stall, and then the next person grabbed it and immediately threw it to the next stall. It's almost a cartoonish scene that happened there. But of course, the final person, when the fuse ran out, was seriously injured. And there the court said that, look, even though this has happened through a series of steps, it was still the direct action of the first person lighting it and throwing it that led through this chain to the person getting injured. In that situation, directness was satisfied. However, in Hutchins and Morn, in that situation, a particular person put poisoned bait down on a property, and then someone subsequently came in with some dogs, and the dogs ate the bait and they died. And there the court said that no, look, this was an indirect action. This requirement for directness simply isn't satisfied in that case for the particular torts that the plaintiff was trying to take against the defendant there. Another important thing to note, that in most areas of civil law, in other words, citizens dealing with other citizens, that mental illness or incapacity usually doesn't lower the underlying standard that a person needs to maintain when they're dealing or interacting with society. And so, for example, in the case of Carrie and Bonham, a person who was suffering some form of severe mental illness stepped in front of a bus, and there the Queensland court said that, look, in this situation where the bus driver suffered long-standing systemic structural trauma and psychiatric illness himself as a result, that the fact that the person was mentally ill was quite irrelevant in terms of determining whether or not they were going to be held liable. However, in terms of trying to determine whether a party actually did intend to commit something or had this reckless indifference, again, a person's mental state or infirmity will be taken into account by the court when trying to determine whether that's actually occurred in that situation. Now, similarly with children, where a minor is being sued in tort. Again, their particular state or circumstances or mental capacity at the time is taken into account when the court's trying to determine whether they intended to do something for torts that require intent. And in terms of negligence, the appropriate standard of care to use for children in most torture situations is going to be the equivalent of an equivalently developed child for that particular age. Whether or not that particular child is more or less mature for that age isn't relevant in making that determination of what the standard is. So when thinking about tort and tort law generally, it's important to note that tort is the umbrella term. It is the broad conceptual thing that we look at or refer to when describing civil wrongs that a party can seek some form of remedy for. And so some examples of these areas are battery, false imprisonment, assault, trespass, defamation, deceit, and negligence. Some of these we've already very briefly touched upon. Deceit, for example, is a remedy that a party can try and seek when they bring an action under misrepresentation, and where the court is satisfied the person has done it fraudulently. And similarly, negligence in that situation where a party has a particular duty to the person in the contract to be careful about making statements to them, and they've fallen below the appropriate standard that duty entails, and harm comes as a result, usually of reliance of that statement, then that is essentially an action under the tort of negligence. I'm going to look through each of these torts, beginning with each of the small specific areas, and then go through negligence in a bit more detail. I'm going to start by looking at the tort of battery. Now, battery is contact. It's usually situations where one person has contacted another person. And again, specifically, the elements are that one person has to directly touch another without consent, or without any form of justification or lawfulness. And in this situation, one person has touched another. Now, the courts call this, or they call it actionable per se. What does that mean? It means that you don't actually need to prove that there was any harm. If somebody touches you, in theory, you can seek redress through the courts. Now, again, if there's no harm, the courts will usually award what we call nominal damages. They won't give you much money. But the starting point is that people are free to live their lives without being touched by other people. Now, that sounds a little odd when set out of context, and context is important here. The courts have said that, look, battery is only going to arise in situations where usually where there is some form of intentional hostility, but it need not. So strictly speaking, it can arise where one person has touched another without, just simply without consent. However, day to day, people have to touch each other. When you're all squeezed onto a tram or waiting in a queue, it's not uncommon for people to bump into each other and touch one another. And the courts, again, in those situations, won't give any award as well. Now, the cases there, Rickson and Star City, involved a person at a casino who was touched on the shoulder by somebody just to get their attention. And there the court said that, look, you have to appreciate that while strictly speaking, yes, you were touched without consent, this is still going to fall within this day-to-day exception in terms of battery. It's not going to be a battery. Fagan and the Metropolitan Commissioner of Police was one of these almost slightly silly stories. The defendant in this situation was stopped by the police. The police asked him to move his car, which he did, and he moved it a few feet. And then he actually ran over the foot of the officer who he was speaking to and stopped. And the officer said, "Hey mate, what are you doing? Please, move your car off my foot." And in that situation, the driver said, "No, you can just wait till I'm ready." And it was found there by the court, look, the actual act of driving over in the first place, probably not going to be battery. The fact that you refuse to take it off probably is going to be in that situation. Because in that situation, you've done that, I guess, deliberately, or and certainly directly and willingly. Now, assault, unlike battery, is not about actually being touched, punched, hit, what have you. It is, in fact, the tort that arises when one person tells another or makes them apprehensive that they are about to receive a battery of some sort. And so, again, the elements there are strictly that a person directly, intentionally, and unlawfully causes another person to have a reasonable apprehension that they are about to be touched. They're about to receive a battery of some sort. Now, false imprisonment is a tort that arises in situations where one person restrains another. And I guess of these torts, particularly for those that end up in retail, and again, this may be familiar to some in the audience, situations where a person has been shoplifting, and that's where these certainly where these cases come from, because if you restrain somebody, you stop them, you tackle them, you stop them from leaving the store because they you may think that they've been shoplifting. You better make sure that you're right, because the courts are, some might even argue, a little too trigger happy to award large sums of money to parties in situations where they are restrained unlawfully. Now, again, the elements here is that false imprisonment is going to come up where a person is sort of directly and either intentionally or negligently creates a situation where the plaintiff is unlawfully restrained and stops them from taking reasonable steps to escape. And in Myers and Sue, that was the situation. Now, the way they talk about this reasonable means of escape is if a person is restrained and told that they have to stay there. For example, in the situation of Myers and Sue, where there the store Myers had restrained Mr. Sue and said, "Look, you can't leave." But then they sort of argued to the court that, well, you know, he could leave if he wanted to. We weren't going to physically stop him. But the exact words the courts use is that, look, in situations where a person's will is overborne, where they feel that they can't reasonably escape from that situation, false imprisonment is going to arise, and it can end up being quite expensive for the party, again, particularly in the retail situations where they do restrain people who turn out to actually not have stolen goods. So it's something to leave in the back of your mind if you are in that situation. Be careful. Be very, very, very sure. Now, there's an area of law known as action on the case, or it's also known as the innominate tort. And this comes up in quite rare situations where the plaintiff can prove that the defendant intended to cause some harm, but they do so in an indirect manner. And I guess the famous case we use for this is Bird and Holbrook. In that situation, a person laid traps. He laid spring guns, so spring-loaded firearms that would shoot people when coming into the yard. And somebody had gone through, got shot by one of these. And there the court said that, look, this isn't going to be a battery. This is not trespass to the person because it's happened indirectly. Nonetheless, they did intend harm to happen, even if they didn't intend it to be for the specific person or classes of person that ended up being hurt. And so there the courts would allow that party to seek damages in that situation. Similarly, in situations where one person says something to another and it makes them upset, and not just upset in the ordinary sense, people are required to have at least some sort of minimal fortitude, but says something, again, intending to harm, or at least to bring some form of result into effect. When they do this and the person does suffer harm as a result, then that person making the statement can be held liable. Now, the example in Wilkinson and Downton is where one person told a woman as a joke that her husband had been killed. And it doesn't seem like a very funny joke, does it, when I say it like that? But nonetheless, she was distraught and went home and was distraught and very, very sad about that. And she took it to court and she won. And she said, and that's it. The court said in that situation that, look, there you were intending to harm. Now, in your mind, you may not have thought that it was going to be very harmful, but really, when you're intending things, the result that happens may not be exactly what you intend. But because you intended some harm to occur, you can't turn around and say, oh, well, it wasn't, I didn't really mean for all of this harm, the greater amount of harm to occur. I only just meant for it to be a little bit. So something just to leave on the back of your mind. Don't actively seek to harm other people directly or indirectly, particularly throughout commercial practice. In tort, we use the word trespass in a very broad sense to refer to causes of actions that have this aspect of directness. And you'll notice that the trespass to the person, things, assault, for example, or battery, they must occur directly. The person must directly do something, or a chain of events be set into motion. Similarly, with trespass to land, one person has to directly enter into the land of another. And again, without this consent or lawful justification. And really, this form of trespass is the one that we most think of when we hear the term trespass. Now, strictly speaking, though, trespass in the legal sense means all forms of direct interference with a person or their property, physical, tangible property or land. Most people think that trespass just means to land. And that's fine, but it's important to note here that generally when one party trespasses on the land of another, there's not usually much harm done. And so that's an important thing to note, that while trespass is actionable per se, you can always go to the court and win. If there's no actual harm done to your land, and you've got to prove that harm and quantify it, your damage was not going to be very large. Usually you'll be awarded what's called nominal damages as a result. Now, another tort involving land is this idea of nuisance. Now, there's actually two broad categories of nuisance. Here we're referring to private nuisance. That is when one particular party is having their enjoyment of land unreasonably interrupted. And so again, the elements are that if a party unreasonably and substantially or materially interferes with the use of enjoyment that another has in their land, then that the party who is being upset can bring an action in the courts and seek some form of remedy. Now, again, the amount of dollars that are awarded for nuisance, and again, there's quite a lot of case law because it's a very, very old cause of action. It goes back 800 or 900 years. And so, but generally the amounts, if you can't demonstrate or prove some form of loss or harm to your land, they're usually not very much. But also note that nuisance can arise in situations where the other party doesn't actually go onto your land. For example, if they put a weed killer into the soil and that leached or leaked onto your land and damaged your trees, in that situation, nuisance is an area that you could explore to bring about a remedy from the court and seek some form of compensation. Now, the next two areas, conversion and detinue, fall again broadly under the umbrella of trespass, but they're to do with goods. Now, conversion is a situation where somebody has done something willfully. So sometimes that can be because they've intended to, but other times situations where they're not aware, usually of the underlying legal rights and where things sit, where they've willfully gone. And the phrase we use is dealt with the goods in a manner repugnant to the immediate right of the person who can claim possession of those goods. Now, in most situations, that is the owner, but there are some situations where the true owner of the goods has, usually through grant of some form of lease or hireage or bailment, given the goods to another person either to look after or to rent or hire for a length of time. And in that situation, the person who has this right to the hired goods, they will have the bare right to sue the other party if, again, a third party comes along and interferes with that. Now, conversion can arise in situations where people pick things up, move them around, take them away. And make note, when we're talking about goods in terms of breach of contract, how and where title sits is important, because when we're talking about contract, if title is passed, you become the owner, or the person purchasing the goods becomes the owner, and after title is passed, at that point that person gets the right to sue in conversion because they have this immediate right to possession. Now, detenue arises where the party who has the immediate right to possession has made a demand of the party who has the goods, and they've refused to release the goods, and so that is the particular cause of actions where they've unreasonably refused to return goods when they've been asked, or when they've been given some form of notice. It doesn't really matter what they're doing with your goods, whether they're just storing them or holding them. If they're damaging them, then you also get this right to conversion, because that's repugnant to your rights as the true owner. But detenue is just the bare right to sue, where another person is just not giving you your stuff back. That's the tort that you have to that you can bring about as a cause of action in the courts. It doesn't require you to demonstrate that they're doing anything bad to the goods at all. They've just not returned them to you. Now, deceit as a tort is one that we've talked about earlier under fraudulent misrepresentation. And again, when arguing misrepresentation, you actually argue both of these things at the same time usually. And that's where a person's made a false representation to you and you've suffered some sort of loss in reliance on that statement. And going back to us thinking about this distinction, you may recall this distinction between a representation and a term, and that if a person's made a false statement and we've relied upon it, if that was a term of the contract, we don't need to sue under the tort of deceit. We just sue under breach of contract. However, if it is not a term, if it's merely a representation, then we can still bring an action and can seek some monetary compensation. However, the key thing about deceit is that it must be false, and you have to prove they knew it was false as well. So deceit can, again, anything where you've got to try and prove or demonstrate that to the court can sometimes be difficult, which is why in the 20th century the idea of, or distinction between only having innocent and fraudulent misrepresentation, negligent misrepresentation, was found to really fill that gap. Next tort we're going to look at is defamation. And again, defamation has an ordinary or lay meaning. That's when one person, either through words or spoken words or writing, says something bad about another person and then publish that or broadcast that to other people. And that essentially that sort of common meaning, which was quite similar to how the courts had interpreted defamation over the years, is now largely enshrined in the Defamation Act, which have been created and now apply uniformly across the various states and territories. And the key part here is that there's three elements. The first is that there must be the communication of information. Secondly, there has to be identification of the person who's being defamed. And thirdly, the information has to actually defame them. And again, there's three ways that can be. They can either just injure their reputation, and the courts of common law always use the phrase exposing them to hatred, contempt, or ridicule. And that's one way of doing it. Or to cause them to be avoided or shunned by other people. You become some sort of pariah or outcast. Or it lowers their esteem amongst people, of the particular group that person or entity that is defamed belongs to. Now, when looking at the actual material itself, first of all, up until relatively recently, there was a distinction between what we used to call libel and slander. This distinction between written defamation and oral defamation. That distinction's been abolished in Australia, and now when they're looking at the subject matter in the broad sense. They're trying to determine whether or not it's defamatory by really looking, and the person bringing the action actually gets the benefit here because it can be done in any of these three ways. It can either through actually looking at the literal text or words that have been spoken or broadcast in some way to determine, firstly whether that in the ordinary sense is defamatory, or it can be a situation where there is what we call a false innuendo. That is when something false has been said, but it's really through reading between the lines that the actual defamatory sort of stuff arises. So, for example, stating that X, Y, or Z has spent all day in Magistrates Court 1. Now, again, if that particular statement was false, for example, the person was nowhere near the courthouse in that situation. But people, when reading between the lines, would think, "Oh wow, this person's actually, have been in court for all this length of time. They must be the defendant in a criminal trial," for an example. And the original part was the words that were said were actually false, and the innuendo that flowed from that was the defamatory part. Now, this is contrasted with a true innuendo, where the words that have been stated are actually true. However, they need to be read in the context or with more facts. So going back to the same example, saying that a particular person X, Y, and Z has been in Magistrates Court 1 all day, but not actually mentioning that they are a student taking notes in the back of the courthouse all day. Now, what was literally said was true. The words that were spoken or communicated, but in reading between the lines, it's still going to be defamatory. So it can still fall under the broad umbrella of being a defamatory statement or subject matter or material. Now, there's one really important thing that a person needs to know about defamation as a tort, and that is the defences that can be raised by the person making or issuing or broadcasting the defamatory matter. They have the onus of proof to actually bring about the defences in the court. This is a really important distinction, and for those, again, in a commercial context, that get in situations where you're going and needing to make statements, press releases or marketing claims or statements, that to remember that the fact that something is true, or what we call the defense of contextual truth, is all well and good, but you need to prove that. The other side only needs to prove, remember, that they have actually been harmed, been subject to some form of ridicule or contempt. You need to do the hard yards from this point forward in order to prove on balance of probabilities that one of these particular areas or defences can be satisfied by the court. And so, for example, if you get the trial dates wrong and you don't turn up, or you don't lodge an adequate defence, you don't have any form of representation at trial, then the other side, they're going to win, and so you can't raise that because you had to be there to actually go and argue these things. So now each of these is now mapped out in the Defamation Act, sections 25 through to 33. So starting by looking at the truth defences, justification and contextual truth. If you, under section 25, if you as the defendant can prove on balance probabilities that what you had said was substantially true, then that will afford a full defence against defamation. You can also, in situations where what you have said or what the actual defamatory matter isn't necessarily true, but it is made in the context of other statements or claims that are substantially true, and you can also argue what they call contextual truth. Now, there you have the extra burden of arguing that the plaintiff's reputation isn't going to be substantially harmed because by this one particular defamatory point, because a whole host of other points are also true. And so as a result, in the context, that reputation's person, the reputation of the person will not be lowered. The next three areas of what's called privilege, and that is in certain circumstances. For example, Parliament. When giving speeches in Parliament, a person is completely immune from, under what we call parliamentary privilege, from having defamation actions brought against her or him in the courts. Similarly, the publication of parliamentary matters or of decisions in the courts that are made, the publication of those and reporting on those is a complete defence as well. Qualified privilege is in situations where one party has a particular interest in matter, and that's imparted to that party in circumstances the court considers to be reasonable. That will be a defence to defamation as well. Also, an honestly held opinion by a party will constitute a defence to defamation too. A statement of opinion, first of all, has to be honest. Secondly, that it has to be about a public matter or something of public interest. And thirdly, it must be clear that it's a statement of opinion rather than a statement of fact. In other words, actually having a truth component behind it. That will afford itself a defence against defamation. Similarly, under Section 32, you'll have situations where parties are like publishers or booksellers involved in the chain of publication of things. And in that situation where I guess the primary source is the actual party issuing the defamatory matter, the ones who are actually creating it, the parties that subsequently carry that material through the public are usually innocent in those sort of situations, and they are protected under Section 32 as well. Finally, if the court, if the defendant in the situation can argue to the court that the amount of loss of reputation is very, very, very small, there's not much harm there at all, that can afford itself a defence under Section 33 of triviality. And make note that the actual reputation of the plaintiff in the situation is of great import in this situation. For example, a person who has long-standing continuous criminal activity and behaviour and convictions, being accused of a particular crime, like falsely accused of being found guilty of a particular crime, is going to be, I sometimes find it difficult to argue the reputation is lowered, particularly if the crime that they've been accused of is actually less than other ones that they've actually committed. In that situation, their reputation really isn't going to suffer much harm, and as a result, the courts are unlikely to grant any award at all if that defence is raised. Finally, there are some defences in the common law that are preserved by the Act as well. And one of those is the implied constitutional right that flows from Longy and the ABC and Coleman and Power. In those situations, a person is allowed to make statements that might otherwise be defamatory in the context of political discussion and debate, where, again, that is not something that's been overtly stated in the Australian Constitution, but the courts are happy to stretch that and lend some weight to the fact that, look, in order for there to be a parliament, for example, that is voted upon, people have to talk about it. And so as such, that is preserved in our law and legal system. The largest, most heavily litigated, and arguably the most important area of tort law that you really need for commercial practice is under the tort of negligence. Negligence is or arises in situations where one party has a duty of care of some sort to another, and the standard of care that duty entails, they, for however reason, have fallen below that standard, and harm has come, some form of damage has come to the plaintiff as a result of falling below that standard. Now, in that situation, negligence arises, and the plaintiff can bring an action if they can prove all three of those actions: that a duty of care exists, that the appropriate standard of care that duty entails has been breached, and that harm was caused by that breach. Now, the concept of negligence has been around for a very long time, but it wasn't until Donoghue and Stevenson in 1932 that in British law it was recognised that a duty of care could arise in circumstances other than where there was what we call an established category. Now, prior to Donoghue and Stevenson, you could still sue under the tort of negligence, but you had to be in a situation where you, as the plaintiff, were already owed a duty at law by the defendant, purely from the particular set of relationship that the two parties were within. For example, a passenger is owed a duty by the driver, or a client is owed a duty by a solicitor, or a patient is owed a duty of care by a doctor. Regardless, in each of these situations, regardless of whether there is a contract. Contract law, remember, is a distinct and separate area of law. Sometimes these two duties can coexist. A doctor, for example, may have contractual obligations as well as tortious ones. But the key distinction or pivotal moment in the tort of negligence occurred, as I said, in 1932. Donoghue and Stevenson, and that was a situation where two women went into town in Paisley in Scotland, and one of them purchased a bottle of ginger beer, and she gave it to her friend, and her friend poured a little bit over her into a glass, I believe, had most of that glass, then poured the rest of it to have the rest, and a snail fell out. And she was sick, and the court accepted that she'd suffered some form of harm through illness, or what have you. And there, the real difficulty that arises there is that because she was not the person who purchased the drink, there was no contractual duty in that situation between the seller and the person who actually suffered the harm. So this was the important distinction, and this went all the way into the to the House of Lords in the UK. And there they said that, look, famously, Lord Aiken said, there is a situation where duties can arise on the facts through where there are others who are closely and directly affected by your actions, that you need to assume some form of control or carefulness over what you do. And he called that the neighbourhood principle. And while we don't use the exact formulation for negligence, that really is the point in time where this duty of care being able to be established on the facts started to, or really flowed from. It really started at that point. So when trying to establish a duty of care, again, as satisfying the first element of the tort of negligence, if you're in an established category, so for example, you're the client and you're trying to sue your doctor, or you're the client, you want to sue your solicitor, in those situations, you don't have to do anything else for the duty of care element at all. You just have to demonstrate that you were inside that existing category, and that will tick the box. And there are lots of them. The English common law has been developing these for 800 years. The much harder situation is where there isn't an established category. There, you have to go through and argue to the court that the defendant ought to offer you a duty of care. They ought to show you an amount of care because the particular class of persons that you were in, it was reasonably foreseeable that that class of persons would suffer some form of harm. And you have to argue that there ought not to be any strong policy reasons, again, whether there'll be a strong burden placed upon businesses, or say a community group that you might be trying to sue, or a council. Be mindful of the courts are reluctant to find duties in situations where it's going to create a large burden, particularly on the public purse. You have to argue that. And you've also got to argue the salient features. In other words, the particular set of circumstances for this case ought to be in your favour to try and essentially argue that a duty of care should arise in this particular situation. Now, if you have managed to argue that a duty of care exists, the real important question, or the next question to look at, is that, well, so what? Okay, a duty of care exists. What does that actually mean, though? So for this second element, the breach of duty, it's really split into two halves. The first is trying to determine, or based on this particular duty that the defendant owes the plaintiff, they need to maintain a certain, what we call, standard of care. And this is a question of law. This is up for the judge to determine. Certainly both sides are going to be arguing one way or the other to help their particular clients, but fundamentally this is a question of law, and a judge needs to determine, basically taking into account the foreseeability of risk, the significance of any risk, and what a reasonable person would have done in this particular set of facts, or these particular circumstances. Now, this is these days is mapped out in the Civil Liabilities Act, and the types of precautions that a reasonable person would take into account are actually mapped out. You have to take into account the probability of harm, the seriousness of any harm that might occur, the cost of taking those particular precautions, and the social value of the particular activity that's creating the risk of harm. And so once the judge has determined what the appropriate standard would be for a reasonable person based on this particular set of facts, what they ought to have done, the next part is pretty easy. The judge just needs to look at what actually happened. So as a question of fact, well, what actually happened in the set of circumstances? Did they reach that particular standard, or did they fall below it? And this is important to note, because it's only in falling below that standard that we use to examine the next element, which is to do with the causation of harm. And it's really important to just reiterate the point that the harm has to come from the conduct falling below the standard. That was the breach. And the plaintiff, though, needs to prove, sure, the conduct fell below that standard, but again, we sort of ask, well, so what? What does that mean? It means, from the plaintiff's perspective, that they need to prove that falling below the standard caused their harm or their loss. And this is a two-step test. You've first got to prove the causation aspect to it, and then you've also got to disprove remoteness. In other words, you've got to prove that the particular harm was not too remote. And so the first of these, when we're looking at causation, is causation is a very tricky term in law. There's a lot of discussion, a lot of writing, a lot of cases where judges argue about what causation really means. And so I think it's helpful to break it up, certainly in the Australian context, into three overlapping but not dissimilar tests. The first one is to just think about what the word cause means in its ordinary sense. For a layperson, we have an intuitive understanding that X causes Y. So, for example, when thinking about a fire, it makes natural sense to us to think that if there is one person's holding a something that's alight, a lit torch, for example, flaming torch, and then they hold it against the surface, that causes the fire that would, say, burn the whole house down. That's a very intuitive way of looking at it, in a lay way. And again, without getting too much in the technicality, strictly speaking, the fire is caused by the rapid oxidization of organic matter. And so if we think of it like that, that's not a very lay way of looking at it, but strictly speaking, that is what is causing the destruction. Now, lawyers aren't scientists, and they're not accountants, they're not economists, and when trying to develop these tests in situations where it's not always very clear, they have taken this idea, this commonsensical notion, and then sort of try to pare that back a little bit, to try and refine it a bit. And so we think of it in terms of the but-for test. Would harm have come but for the breach? And remember, the breach is falling below that particular standard. And both of these things should be quite familiar to you if you've seen previous recordings, because these are similar to the tests that the courts use for contract damages when trying to work out the causation aspect of contract law. They use these quite simple tests. However, what the courts have found, particularly in more recent times, where there are circumstances where there are multiple aspects of causation, lots of different things could lead to a particular result. And this was particularly noticeable in the asbestosis cases. So when people had lung damage from asbestos, and this was problematic because sometimes you could take one deep breath of chrysolite, the material which they would mine and then make asbestos products with. You take one breath and then you could develop horrible terminal lung conditions, the illness just from one big deep breath. The trouble was, some people could be engaged in doing this, mining asbestos, and be involved with it for a very long time and not develop these symptoms. And of course, these sort of famous stories about James Hardy and other sort of entities that were involved in the construction of asbestos materials, wheeling out the one person who survived being exposed to asbestos for a long time. And this caused a lot of difficulty from the legal sense, because the test of causation really it broke down. It really didn't work in those sort of situations. And so in more recent times, as a result of these, in the last sort of 10 to 15 years, the courts have developed this material and substantial cause. We accept that, look, there could have been lots of reasons why a person developed, for example, asbestosis, damage to the lining of the lung tissue. And yes, we accept that that could have been a long-term smoking. But being exposed to asbestos as a point of law still materially contributed to that particular harm. So under a contemporary test, you don't need to prove that it was 100% caused as a result of this particular breach, only that it was a substantial reason. It's very, very likely that the particular type of harm flowed from the breach, even if it's not the only thing that contributed to this particular harm as a test of causation. Now finally, when looking at the test of remoteness, it's pretty straightforward. It's whether or not the plaintiff can prove that something just isn't too far removed. Now, again, if we think about the sort of chains of causation that could occur, and the overseas tank ship case, there's two of these. This is actually the first of two. We call it the Wagon Mound number 1. Now that involved a situation where a ship in Sydney Harbour had some what they call bunkering oil that they'd used for lighting their furnaces and such like. And they let it out of the boat, and it floated across the harbour, and there were people doing some welding on a wooden dock on the other side of the harbour. And in that situation, the oil went over there, the welding sparks ended up getting on some cotton, setting it alight, and it burned the entire docks down and destroyed or seriously damaged several ships as well. In that situation, the courts just said, look, this harm, this loss is just way too remote. It's not reasonably foreseeable that putting this oil into the water was going to lead to that particular harm a long way down in terms of the chain of events. It was not reasonably foreseeable for a person in that situation to really be able to contemplate that final amount of harm, and as a result, it was going to be too remote in order to claim. Situations where the plaintiff has succeeded in all three elements of the tort of negligence and they're going to receive some form of remedy, the plaintiff, though, can counter-argue one of the defences. And the two we're going to talk about here are voluntary assumption of risk and contributory negligence. The first of these is a pretty hard ask. It is basically saying that in situations where the plaintiff knows fully about all of the risks involved with the particular activity and has voluntarily assumed those, either chosen to ignore them or downplay them, then that the plaintiff would be denied all remedy. In other words, this is a complete defence. This is a difficult, it's a pretty difficult defence to raise, and certainly in Woods and Multisport Holdings, a case involving indoor cricket, there the court, again, there were split decisions in that case, but one of the judges that talked about this said that, look, in that situation, the guy who's playing indoor cricket, which does carry certain inherent risks as part of it, it was only his second game. And in that situation, you can't, hand on heart, and certainly the law won't entertain this idea that you voluntarily assumed all of the risk with full knowledge of what those things were. Now, this might have been different, and the court does recognise with an experienced cricket player in the same situation. But in that set of circumstances, it really wasn't going to fire. Now, with contributory negligence, the idea there is that, look, if in a situation the plaintiff does succeed, but they were in some way culpable, in other words, they contributed towards the particular loss themselves, the court has the power to reduce their damage awards. In fact, they actually have the power to reduce the damage awards by all the way up to 100%, effectively defeating the claim. And essentially, for contributory negligence, the test just operates in reverse. It then becomes the plaintiff who, the defendant's trying to argue that the plaintiff is negligent, so they have to argue that the plaintiff has a duty of care and that the appropriate standard of care that that is applicable for that particular plaintiff in that set of circumstances, and again, this is mapped out in section 23, that appropriate standard of care, that their particular conduct fell below that, and as a result, that they contributed in some way to the harm that suffered. And again, in that situation, the courts do have the power to reduce the damage awards in some circumstances. For example, if the plaintiff is intoxicated, by default, the courts will reduce the damage awards, and they'll reduce them by, usually by default, by 25%. And they can reduce them all the way down to zero, defeating the claim. Finally, going to look at damages. Now, damages, again, are a money award that the court grants in order to compensate somebody. Now, damages in tort operate differently from damages in contract law. And the reason for that is that fundamentally, damages in contract are to put you in the situation where you would have been if the other side did what they said they were going to do. Whereas damages in tort are designed, so far as money possibly can, to put you back to where you were before the wrongdoing occurred. And so that's the really important distinction between the two. That they're both compensatory, but the damages in contract are designed to compensate for the agreement that you make, or the loss of that agreement, whereas damages in tort is to compensate from the wrongdoing, to put you back to where you were. It's important to note, though, that for the intentional torts, that you can claim damages. In other words, this test for remoteness, that similar to what we have in contract law, means that you can actually claim things that were the natural and probable consequence of the tort arising. It doesn't have this reasonably foreseeable test or component as part of it. And that kind of makes sense in that when somebody is intentionally doing wrong to you, it seems a little bit incongruent for them to turn around and say, oh, well, it wasn't reasonably foreseeable that certain types of harm flowed as a result of my wrongdoing. And the courts, they really they smack down on this, where people are willingly and willfully going and deliberately hurting other people. They don't really get the benefit of being able to limit their damages in that way. However, for the non-intentional torts, and particularly for negligence, you can only get the amount that is reasonably foreseeable in terms of loss, and that goes back to this idea of remoteness as well. Now, the final thing I'll just add is that usually you are being compensated for economic loss, or the damage, or again, whatever the money amount that's required to put you back to the situation that you were in. And this can, though, include psychiatric illness or injury. Now, we hear these stories in North America, for example, of people being able to claim huge amounts of sums for compensation for mental distress, and that's not really the case here. The plaintiff in these circumstances needs to quantify the amount of emotional harm that's done or flowed on to her or him. However, it is important to note, though, that the courts in tort can award aggravated and exemplary damages. Exemplary damages arise in situations where the defendant has done something that the court needs to punish in some ways. That this needs to be an award needs to be made in order to deter other people from this conduct. Now, it's interesting because this idea of exemplary damages is still going to the plaintiff in this situation. So if the court feels it appropriate to punish the person, and remember, punishment's not fundamentally the purpose of tort law, the damage award nonetheless goes to the plaintiff in that situation. And this is contrasted from what we call aggravated damages. Aggravated damages arise in circumstances where the conduct of the defendant for this particular tort was just so bad that a regular normal amount of damage to put the person back to where they were is simply not sufficient. Their rights have been dramatically or radically infringed upon. And so an example of aggregated damages for something like false imprisonment, for example, where security guards or police officers or other citizens might detain somebody and stopping them from leaving somewhere. That's a situation where you would get, and again, false imprisonment is difficult to usually to calculate these things, but you'd expect a moderate to intermediate amount of compensation for that. If, however, in those circumstances, and again, this has come up in some cases, some quite disgusting cases, they laughed at the person and urinated on them while they were being imprisoned, that is a situation where aggravated damages are going to apply. That's gone above and beyond what the courts would normally compensate a person with. Their rights have been dramatically and seriously infringed in that situation. And it is in those situations that aggravated damages are going to apply. And also, make note, I mentioned this earlier, that in some situations, particularly for the torts that are actionable per se, if there is no harm that's come to the plaintiff, but nonetheless their rights are infringed, the courts by default will award nominal damages. This is usually a token amount to represent the infringement of the rights. But the key part to note, though, is that the plaintiff has still won, even if the award is merely $100 or $10 or $1 to represent that. They've still won the particular action, and as a result, costs will flow to the winner in those parties. So it's important to note that even in situations where parties only award nominal damages, they will still get, in most circumstances, costs awarded to their benefit to compensate them from the time, effort, and legal expense needed to go to court. So I'm hoping this recording is useful, and I'm hoping that you guys have developed at least a basic understanding of where tort fits in our civil law system.